Refugees have faced suspicion and hostility, including tough security crackdowns in the wake of Al-Shabaab-related attacks in Kenya in revenge for Kenya's military involvement in Somalia. Most recently, after the Westgate Mall attacks in which at least 67 people were killed, human rights groups have come to their defense.
I'm yet to see any proof.
Refugee-burdened Kenya is seeking legal avenues to reduce the number of refugees in the country. In the controversial security laws, Nairobi sought to put a cap 150,000 refugees at any given time. That clause among 7 others that the High Court nullified.
It means that for the country to reach the 150,000 mark, not only must there be no admission of refugees, but that there has to be expulsion of about 430 refugees. The effect of Section 18A is to violate the principle of non-refoulement, which is a part of the law of Kenya.
1,500 Somali refugees have been repatriated following a repatriation agreement between Kenya, Somalia, and the United Nations Refugee Agency. Kenyan laws are, however, silent on what happens to those wishing to remain in Kenya. Some have been refugees for more than 20 years.
There is a lacuna in law. There's a gap. There's a big gap in the law in terms of how does a refugee, if at all, he can transition or he or she can transition from that status into citizenship status. So these are the type of conversations that we need to be honest and open about, to discuss and to find out.
Monday's ruling giving them relief, if only for a little while. Sarah Kimani, SABC News, Kenya.